All right, ladies and gentlemen, we are now convened for the hearing. We're going to start with House Bill 960, being late in the afternoon. I encourage you to keep it brief if we can, but I do want you to be able to state fully what your position is. All right, now with that, we'll start with House Bill 960 and Representative Smith. Which one is yours?
960 is.
Oh, I'm sorry. I'm sorry, Representative Leverett. House Bill 960.
Thank you, Mr. Chairman. Let me sort of gather my world together here for a second.
This is the Office of Inspector General.
Thank you, sir. Yes, so as you mentioned, Mr. Chairman, this is a bill that would give statutory basis to the Office of Inspector General, which exists within the governor's office within the executive branch. Currently exists pursuant to an executive order, which is getting rather long in the tooth, and we'd like to give the office a statutory foundation. Primary purpose of the act is to allow that office to issue warrants and subpoenas, and also to have post-certified officers on staff there. So none of that has changed, but a number of members of the committee expressed some concerns during the hearing and after the first hearing we had. So we've made a number of changes, and those are reflected on the substitute that should be before you. Hopefully it's LC 44-1984S, I believe is the correct number.
Yes, that's the one I have. Thank you.
And I'd be glad to just kind of summarize those changes, and also would be happy. I've kind of marked up mine so I can go through and show you exactly what the changes are.
If you don't mind.
Be glad to. So one of the concerns expressed was that as originally drafted, the bill provided for appointment by the governor, but for an indefinite term with removal for cause. We've now fixed the term at 6 years. We've structured it so the initial appointment would expire the end of this fiscal year, June 30, and then the new appointment would then pick up from that point and run another 6 years, and they would go in such a fashion. If there was a resignation, there would be an appointment to fill the unexpired portion of the term, and we did preserve removal for cause, and we simply also added some process in there. There would have to be a written notice and that sort of thing. Based on some concerns, we did clarify that nothing in this act would diminish or take away authority or power of the Attorney General's office. And we also, at their request, added a provision at the end to clarify that enforcement of subpoenas and or any process, if it's to be in court, would have to be with the participation of the Attorney General's office. So we tried to address those issues. They're not taking a position on the bill, but they did request that change, and we accommodated it. We made a number of changes to make it clear that the jurisdiction to investigate is limited to the executive branch. It does not go beyond that point. And we provided that the Inspector General would investigate based on complaints, not on his own initiative, as was in the initial bill. And we addressed some issues about reports. I think Representative Holcomb had expressed some concerns, some other members. So we've combined a few of the provisions on reports so that one report would be issued at the end of an investigation where a finding that fraud, waste, or abuse had occurred. And we've incorporated some provisions that it would not be, the presumption is to be not only reported to the governor, but the report would be released publicly unless it would compromise a criminal investigation. And the IG also would have authority to redact portions of the report if authorized by the Open Records Act. And there was a provision in here, this is a little bit more of a minor tweak, that said that a finding in this investigation, if an employee had committed fraud, abuse, waste, whatever, would be basis for termination. And we tried to clarify that because of the language, it almost made it sound like that could be a basis for termination of an elected official. And we tried to clarify that of the elected officials, constitutional officers, that would not apply. It only applies to people who are employees and were otherwise subject to termination. So I think that generally summarizes the changes, and I'd be glad to go through the bill now and hit the detailed review, which again is for which this committee has passed into the legendary.
Okay, if you would begin, please.
All right, thank you. On page 2, up in line 14 and 15, there was a phrase at the end of that. This is the definition of the word abuse that also included or improper practice that does not involve prosecutable fraud. We felt like that language was a bit unclear, so we have removed that language. Down in line 20, if you go out about halfway on the line, the words in the executive branch of state government was added again to clarify and sort of narrow the scope of the jurisdiction. And there was at the end of line 21 was the word after commissioners and presidents, and we weren't aware there was anyone in the executive branch that has the title of president, so we just simply removed that. Down in line 27, again, at the end of that line, the phrase in the executive branch of state government was added to make clear that officer references to the words officer is likewise limited. If you jump down, Mr. Chairman, to the bottom of that page, bottom of page 2, line 39, after the section cross-reference, that sentence that begins the jurisdiction, authorization, powers, and duties, that entire sentence, which is saying that the granted to the office shall be in addition to and not in contravention of any and all jurisdiction, authorization, powers, and duties of the Attorney General or any other state or local law enforcement agency. All of that was added to make it clear this does not try to withdraw from the AG or any other law enforcement official any prosecutorial authority she may have. Now, paragraph B, there were quite a number of changes. This previously just read, the governor shall appoint inspector general who may not be removed from office except for good cause. That was all that said before. We've now made basically after shall appoint inspector general, we deleted the remainder of that sentence, and then the initial appointment shall expire is more or less all of that has been added. We have the concept of removal only for cause has been preserved, but we've also provided it would be with notice and that the removal can't be retroactive and such as that. So all of that paragraph basically is new. On line 55, there was an additional phrase as well as other persons doing business with any agency or receiving state funds. We've removed that to kind of tie down the scope of the authority. And then down in line 63, we also deleted a phrase at the end of that line that was or investigate such actions on his or her own initiative. Going to page 4, at the top of the page, line 68, the phrase regarding officers, officials, or employees of agencies was added. In line 73, after the word investigation, we added the phrase that results in a finding of fraud, waste, abuse, or corruption. And then after further out on line 74, after the word requested, we added and subject to the provisions of section C of code, subsection C of code section 4512-214, which is a cross-reference within the statutes enacted by this bill or this proposed act. Release to the public any such report unless the public release would compromise a pending criminal investigation known to the inspector general or otherwise be exempt from disclosure pursuant to 50-1872, which is the Open Records Act. We had deleted another paragraph in there about preparing and release written reports because we thought that was an opportunity to release reports before real findings had been determined, and we didn't feel like that was appropriate. On line 79, what is now paragraph 7, the words instruct and educate were inserted in place of the word advise. Down, I guess right after line 85, there was another paragraph there that we moved to a subsequent portion of the bill because it didn't really address duties of the inspector general. It addressed duties of agencies if the inspector general made certain conclusions or needed certain information. So we moved it to another section, but we had not stricken it from the bill. We just didn't think it fit right there. And then on line 88, some of that has been changed a bit. It initially read oversee the activity. Let's see if I can find it. It was oversee the activities of the office, which is the Office of Inspector General, internal affairs units and offices of professional standards within agencies. I think some of there are other inspector general offices within state government, and I think they didn't resent the IG being able to oversee their office. So we changed it to act as a liaison and monitor the activities of internal affairs units, inspectors general, and offices of professional standards within agencies. So some of that language was preserved, but we tweaked it a little bit. On line 90, conduct special investigations and management reviews. We just added of agencies at the request of the governor. And on line 92 and 93, the top of page 5, everything after the word article there, other duties assigned by the governor that are consistent with this article. And then we added, and that involve or concern the management, operation, or personnel of agencies. If you go down to lines 96 to 98, that was paragraph 10 from the previous code section that I just mentioned. So we moved it into that section. It's just saying in an agency where fraud, waste, abuse, or corruption is detected, the agency shall take remedial steps to prevent recurrences of similar conduct, including implementation of a remedial action plan that the IG may propose. Again, we felt like that wasn't a duty of the IG or an authority of the IG. That was an obligation of another agency to act based on his findings. So we moved it into this section. Down on line 105, after the words employee serving in and before the agency, we had deleted any other person transacting business with. There was a phrase there. We just took that out again to kind of further define the IG's authority. And after line 108, before we go into code section 4512-214, there was another paragraph addressing referral to other agencies. And we felt like it was just duplicative of language in paragraph 5 of the previous section, which is on line 70 to 72, which already say he has the authority to refer as appropriate to other agencies of federal or state government. Then down in lines 110 through 114, really, I guess it starts more at 112. This is the provision that said that the person, an employee, can be disciplined or terminated for violation or commission of fraud or waste or what have you. Mm-hmm. And we left it out so it wouldn't be shall, it just may be cause for discipline. And then we added the phrase, if you go to the end of line 112, after the word termination, the phrase by the agency, so long as such official, et cetera, is subject to termination or other discipline. We added that just to make it clear it wouldn't be grounds for removal of someone who had been elected to office. And then on page 6, on line 135, this is really more just a grammatical change that I requested. The language was subpoenas upon a natural person may also be served. And I just didn't think that was appropriate. A subpoena upon somebody. It's subpoenas may be served upon a natural person by registered or certified mail. And so we just made that correction. And then on line 146 on the next page, where it says the inspector general or his or her designee may petition the Superior Court, we've changed that to may request that the attorney general petition the Superior Court. And that was a request of the AG's office. And I believe that is Forrest Gump would say, Mr. Chairman, that's all I have to say about that.
All right. Any questions for the author?
Move to pass LC 441984S if a motion is in order, Mr. Chairman.
I'll accept the motion at this time.
Second.
All right, motion and second. All those in favor say aye.
Aye.
Any opposed? All right, bill passes. Thank you.
Thank you, Mr. Chairman.
And we'll move on to your next one, 916.
Thank you, Mr. Chairman. Let me sort of get my things in order here. So this is the Superior and State Court Appellate Practice Act, Mr. Chairman. As you may recall, this is a product of years of work by the Judicial Council and our judges to try to clarify and bring some sanity, frankly, to the manner of appealing from lower courts and lower adjudicatories to superior and state courts. As Judge McFadden said, we're trying to bring us into the 20th century. We're not being foolish enough to think we can drag this whole process into the 21st century. Right now, we're just trying to get out of the 18th and 19th centuries. So there were a number of comments that we received from various parties, and we've tried to accommodate all of them here. Fortunately for the subcommittee, Mr. Chairman, there aren't quite as many on this bill as there were in the IG's bill. So it's hopefully be a little quicker.
All right.
So these are all, I think, rather technical changes, but they, I think, do improve the bill. On page, I think it's lines 92 through 102. So we're on page 5. that section previously ended at final judgment under review. And ACCG raised a question of who would be the respondent if there really isn't an adverse party named in the proceeding below. For example, if you're just had a zoning hearing or a tree commission, to use Judge McFadden's example. So this just clarifies if it's a quasi judicial decision rendered by state boards or agencies, then the state of Georgia should be named respondent. If it's a decision rendered by municipal officials, it's the city or the municipality. And if it's by a county or school system official, it's that county or school district. So that's actually from line 92 down to 102, that was added. The next change is on line 109, which is, I'm sorry, 120 of the new one. It was line 109 of the original. So just on the next page, and this is what I refer to as the Evans Amendment. I believe Representative Evans was concerned if we were to generate other courts, we don't want to have to come back and amend the act. So we went ahead and put a catch-all that excludes from the provisions of the act any other court from which an appeal directly to the Court of Appeals of the Supreme Court is authorized. So that's lines 120 and 121. Because the courts listed above, that's basically why they're there. If there's already some direct appeal provided for to the Court of Appeals of the Supreme Court. Okay. Then I believe line 171 is the next change. Let's see, where is that? Oh, yes, this was, I think this was Representative Holcomb. He did not like the word hereby. So we struck the word, the offensive word, we excised it from the bill in line 171. So we excised that from line 171. You will note, I hope Representative Holcomb, the delightful absence of the word hereby on that line. Thank you. The next change was we moved quite through the bill. We go to line 504. And I believe 517, excuse me, 504 in the original. This, I think, I refer to as the Oliver Amendment. The bill originally preserved some limits on penalties for frivolous appeal or frivolous claims or defenses, and also provided it would apply only to money judgments. We've removed that language. So 516 and 517 reflect language that was in the original bill as filed, but we've stricken about 3 or 4 lines there that provided those limitations. And I think there was also, yes, there was also the or on 517. It was an and in the original, and so we've changed that to or. I believe that's more appropriate. And then on line, okay, we have to sort of jump down to lines 1237, which are, I believe, on page. Yeah, 1246, I'm sorry. Yeah, section 2-39. That is the section, Mr. Chairman, that corrects some cross-references with respect to the procedure of appealing an assessment from the Board of Equalization to the Superior Court. The head of the Assessors Association and a practitioner contacted us and expressed some concern about preserving some aspects of their procedure. But it would not, I think, implicate some of the policy concerns that were driving the main changes in the bill. So we were able to accommodate them. Specifically, the way that process is set up right now, you file a notice of appeal with the Board of Assessors. That triggers a settlement conference process that both the taxpayer and the assessors go through. And if they are able to resolve the dispute over the value, the matter is concluded. The way we had initially drafted the bill, the petition would have to be filed with the Superior Court, and the assessors were concerned because most of their appeals are resolved at that level during the conference. And that was sort of creating a problem with, well, what do we do with this thing? You know, it's sort of like, you know, you've plucked the spider strings in Superior Court and got them involved. Now, how do you get that? How do you dismiss that? Right. And so we've just sort of preserved it where the petition would be filed here. The filing fee payable to the clerk would be remitted to the assessor. you'd go through the process, and if you could settle it, then, the payment's returned and the petition's discarded. But if you cannot resolve at that level and it needs to move forward, then the assessors remit the petition and the payment, which they've collected from the taxpayer, to the Superior Court. It's a reduced fee also. And then the appeal proceeds pursuant to the act otherwise at that point, which was basically, at that point, the procedures didn't really diverge that much. So we've kind of worked in some of the interweaving of those processes there.
Okay.
And I believe, if I'm not mistaken, there's one other change that sort of kind of goes hand in hand with that change, but what requires us to jump back in the bill a little bit to lines 150 and 151, which are back on
Page 7.
Page 7. Right there on line 150 in paragraph B of 5-3-7, we added that introductory phrase, except as otherwise provided in paragraph 2 of subsection G of code section 485311. That was the one we were just discussing.
Okay.
So we're just providing an exception because there were some slightly different timeframes and deadlines in that appeal process. So of all the comments we received, Mr. Chairman, we've addressed them, I believe, to the satisfaction of the people expressing concern.
Okay. All right. Now, any questions to the author at this point? I don't have anybody signed up. Well, hang on. Chairman Burchett.
Thank you, Mr. Chairman. Representative Leverett, you mentioned the taxpayers, I guess that's an appeal of their assessment.
Yes, sir.
I'm aware of a appeals process for like Cuba and Flippa. Are you familiar with that?
No. You mean conservation use and forest? Yes.
Would that fall in this?
I would think to the extent, once it goes beyond the assessor's level to a superior court, it would, but I'm not actually familiar with that exact process.
Okay, thank you.
Okay. Any other questions? All right. I don't have anybody signed up to speak on this bill, so I'll entertain a motion now. All right. We got a motion and a second. Any further discussion? All right. All those in favor say aye.
Aye.
Any opposed? All right. Motion passes.
Thank you, Mr. Chairman.
All right. Now we're going to come to House Bill 1001 and Representative Smith. Go ahead.
Thank you, Mr. Chairman.
I'm sorry. Go ahead.
Thank you, Mr. Chairman. I bring to this committee House Bill 1001. And just so the committee knows, I've got some experts, Mr. Mark Nelms and Kelvin Almarath, who he and I tread some of the same undergrad grounds as I understand. So I'll have them step in to discuss any of the technicalities. But this bill concerns prepaid legal services. And the current definition of prepaid legal service plans found in OCGA 33-35-2 of the Georgia Code applies if a company enters into any arrangement whereby we undertake to provide, arrange for, pay for, or reimburse any part of the cost of any legal services for consideration consisting in part of prepaid or periodic charges or dues. This bill that we submit to you today amends the definition of prepaid legal services plan in Georgia to clarify that non-indemnity legal service plans that do not pay or reimburse for legal expenses are not subject to regulation in Georgia as a prepaid legal services plan. This bill proposes the following language, which will ensure that all companies offering non-indemnity plans are excluded from the definition of prepaid legal service plans, while those companies that offer insurance indemnity plans remain within the regulatory control of the Department of Insurance. In short, this bill simply addresses the fact that prepaid legal plans were at one time insurance policies and therefore were put under the Department of Insurance for regulation. These plans have evolved and many no longer have an indemnification component and therefore have no basis for being under the purview of the Department of Insurance. This bill says basically that if you're a plan that does not have any insurance provisions, then those plans are not regulated by the insurance department. If you do offer a plan that works like insurance, then you stay under the regulation of the Department of Insurance. And Mr. Chairman, at this time, if it's of the will of the chair and the committee, I'd like to have Mr. Kelvin Almaroth and Mark Nelms speak to this and go through some of the technicalities for us.
Okay. I believe you still have, you wait. Okay. All right, gentlemen, which one wants to go first? And you might need to unmute. We can't hear you.
Can you hear me now, sir?
Yes, sir, we can. Thank you.
This is Martin Elms. I'd be happy to speak first, if that's okay. First of all, thank you, Representative Smith. We appreciate your support and comments, and thank you, Mr. Chairman, and the rest of the committee. Again, my name is Martin Elms. My current role, I'm Assistant General Counsel for Prepaid Legal Services, Inc. in Oklahoma. Prior to that time, approximately 19 years of my career as an attorney was with Riggs Abney, Neal Turpin, Orbison, and Lewis, which is the Oklahoma provider law firm for prepaid legal members here in Oklahoma. We have plans in all 50 states, including Georgia. Very proud the company actually is celebrating their 50th year this year as a company. And I think a lot of people are surprised by that, how long legal plans have been here. And as Representative Smith presented very well, and I appreciate his remarks, there was a time when our company, the plans did function like insurance. A member or an insured could go to a return of choice or seek a referral from their office, who would then either reimburse the member or pay fees for those services. And mentioning my firm, they were one of the first law firms to become what we call provider law firm for prepaid legal, and that was back in 1987. And that's when the model for the services really changed, and that change is really what makes this not insurance. Because at this time, we no longer reimburse, we no longer indemnify, we no longer pay for those fees. We just simply pay a small monthly, what we call per capita administrative fee to the provider law firms. And then they, of course, provide the services. Prepaid legal themselves don't provide the legal services. Those are provided by law firms and also referral attorneys. Right now, just so everybody has a big picture, the vast majority of states no longer regulate us, and that's up to 39 states now. We have been successful in other states like Tennessee and Texas, Nebraska and Arizona, where we need to get legislative change similar to what we're asking for in Georgia. Some states, their statute was such that they just needed to take a fresh look at us and confirm, yes, you're not insurance. And so that's really the purpose of the bill, is to really modernize Georgia law like we've done in some other states, to make clear those plans that are insurance should be regulated by the Department of Insurance. Those are not, should not be regulated. And of course, I know attorneys are on the committee, and myself being an attorney, that certainly does not take away from the purview of the bar or the oversight of the bar and the services provided. It's simply related to the Department of Insurance. And I'm glad to entertain any questions, but I would just say too, I did get to meet the insurance commissioner for the state and met with many of his team, and I think now they fully understand how we operate and how our services are provided, and I think they're comfortable in what we're asking to be done.
Okay. Chairman Administration.
Thank you, Mr. Chairman. Thank you, sir, for your testimony. So I understand that it's not insurance. I get it. I guess my confusion is I've always been under the impression that an individual can only be represented by an attorney or a firm with a direct relationship for that representation, and that you cannot have a third party company, say, with in-house attorneys who are providing legal representation, because the state bar does regulate the practice. There is regulation, and that there are ethical responsibilities the attorney has ethical responsibilities to the client, which cannot be superseded by a corporate employer, somebody that the attorney also works for. Can you help me to better understand what conceptually this is? Is this just referral? Is this an amount is collected, and then when a legal need arises, you find a local lawyer to represent the client? Or is there an actual attorney-client representation between your business and the person who needs assistance?
Thank you, sir, and very good question. And I know Mr. Amaroth, who is with the Georgia provider firm, will be happy to address some of this as well. First of all, the issue at hand is actually just related to the Code and Insurance Commission. These plans, like I said, we're in our 50th year, and we're in all 50 states, and we have no problem related to how the services are provided, because our company doesn't provide those services. And we certainly don't have any fee splitting, et cetera. All services are provided, like in Georgia, obviously, from Georgia licensed attorneys. If they happen to need help, for example, in Oklahoma, I've helped a Georgia member in the past. They would simply refer that to the provider or a referral attorney in Oklahoma who's licensed to handle that particular legal matter. So bars, we have no issues with any bars across the country in legal plans. And that's a great question, because I think, as long as we've been around, I think there's still some misconceptions related to legal plans and how they operate. But it's certainly a non-issue related to the attorneys who provide the services, and I'll let Kevin address that for Georgia. But again, basically 19 years of my career has been dedicated to providing legal services. I will also say that being one of the early providers, one of my former partners at Riggs Abney is a former attorney general for the state of Oklahoma. And one of the former founding partners of that law firm was appointed as the chair of the Access to Justice Commission by the Oklahoma State Supreme Court. So I'm very proud of that, but that will, I hope, help show you that these are full service law firms that provide services for members and non-members. The only difference is when a member comes to them with a legal need and they have a membership, of course, there's certain benefits that are provided under that membership. That's the only difference. Our company has nothing to do with the services ourselves.
Follow up.
No follow-up.
All right. Representative Evans.
Thank you, Mr. Chairman. Can you talk to me a little bit about why this bill is here? Did something happen? Any complication, any particular incident that led you to send this bill to us?
Thank you for that question. Actually not. What we did, and it's been like I mentioned some of the other states, we honestly just took a look at the different states where we were quote regulated as insurance and looked at the laws. And some of the states, like I mentioned, and this includes Georgia, we just needed to do some modernization, I would call it, or clarification as to plans that aren't insurance and plans that are. A big reason for this are really twofold, which I appreciate we gain support from everyone on, and that is one, access to justice is real. I mentioned the Oklahoma Supreme Court. Almost every state, and it's been recent, has put together access to justice commissions or something similar. And I know Georgia has a focus on that. And this is a big reason I've spent 25 years of my career doing what I do. And legal plans for everyday individuals, families, and small businesses provide meaningful access to the legal help they need. And they get access to firms like Riggs Abney and like Demi Parker in Georgia. So one reason we're asking for this is in states where we have been able to provide these changes, it has helped show that the number of those that getting help and the access to justice issue that is real, it has helped in that area. The other part of this is simply pro-business. And that is, most everybody in the room can appreciate, but when you have those type of regulations, et cetera, there's different things that businesses have to address. And if it doesn't, it shouldn't be addressed because they're not insurance, and that's what we're asking for. But this has clearly also been helpful as far as pro-business in the states where we've gotten change. And so those are two things, ma'am, I would bring up is the main thing. And if that didn't answer your question, I'm happy to go in more detail, something else.
No, that's fine. May I have another question, Mr. Chairman?
You may.
And I guess it's a two-part question. Are you moving for legislation like this? I guess it would be the other 10 states that currently regulate this by insurance. Are you looking for changes there? And then secondly, are you saying that more law firms will be involved as providers for companies like yours if this is not regulated by insurance? Is that you said it gets better when you get the insurance regulation out of it. Tell me what's different. What's the barrier and why?
Sure. Well, I mean, one, we do have what we call independent contractors who are associates who can market our products. And not so much in Georgia, but many of these other states, some of the regulations were really prohibitive for them because most of them who can sell our products like that, market our products, they don't do it as a full-time job, right? They're just independent contractors, but as meaningful income. So when I say pro-business, that's one reason. And on the other, you asked about the other states that we've been looking at. And I will say this, yes, ma'am, we are looking at other states. I mentioned the ones we've gotten changed recently. Tennessee was one, the others I mentioned. I don't mind telling you in Arkansas right now, it's just a matter of when we could get a session because we have support there to clean things up, so to speak, in Arkansas. And we have the commissioner's support there. And I don't mind telling you, actually, right now we're looking at New York. New York is one where, and it's not a negative to New York at all, but it's really, especially through the pandemic, the need for legal services from individuals, families, small businesses, because of cost or not knowing where to go, and the regulations there in New York, I'll just tell you, have caused a restriction on people getting the legal help they need. And I've done this a long time. I'm a firm believer in that. And I will say we had an Access to Justice Commission. CLE was what it was, and a very tenured judge from New York came and spoke, and they just brought up a landlord-tenant issue, and how not having access to legal help, what that caused that family, what that caused that individual, and it was just a real powerful speech. And I was sitting there thinking, New York is one that, because of the regulations, we could do so much more there and help so many more people if they didn't have that. So we are seeking to address in other states. We are.
One final question.
Sure.
Thank you, Mr. Chairman. I'm having a hard time understanding how this is not like insurance, because I think about my health insurance. I have insurance through Blue Cross Blue Shield, and then I go see the doctor, and Blue Cross Blue Shield pays part to the doctor. I pay part to the doctor. It seems like exactly the same thing. I have a insurance policy through your company, prepaid legal, and then I go hire one of these attorneys that will work through your firm, and you pay them some and I pay them some. So tell me how it's not like insurance.
Great question. And that's why the change, if you notice, we don't pay those fees. Once they go to Demi Parker, and again, Kevin can comment on this. We just pay an upfront per capita administrative fee basically out of that monthly membership subscription to the provider. We don't pay the attorney fees. The provider agrees to provide those services. There are times Kevin can expand on where they may need to then hire that attorney for things that aren't enumerated in the membership plan. And that's up to them to contract with them directly. So we don't reimburse, we don't pay fees, we don't pay part of the fee. And that's you're exactly right. That's the reason we're not insurance. There are other plans out there, ma'am, that do reimburse or pay. And those particular plans will still be regulated under the insurance statute.
One follow-up. I just trying to understand this. It's been a long day in my brain. I really want to understand this. So is this a plan where no matter how much I pay in as an individual, the amount you're going to pay the firm for me never changes?
Correct.
So I could pay for years and years and years. I could pay for 10 years. You're only going to give $100. I could pay for 5 years. You're only going to give $100.
Well, great
You're
question.
capped.
Well, it's a monthly subscription. So it's per month because the member, of course, has the right to cancel membership any month or any time. So it's just a monthly, basically part of the subscription fee they pay, ma'am. But through that, then through your plan or any other subscription plan you would have, you then would contact your provider law firm, Demi Parker. Many of the benefits, again, are covered under the plan. For example, if you have a personal legal issue today, you could call them and get a no charge consultation by phone. If you need documents up to 15 pages, it is a no charge for that personal legal need. You can get a letter written by Demi Parker for the plan. And so those, again, enumerated benefits, you wouldn't pay any additional to Demi Parker. We don't pay any additional to Demi Parker. Now, if there came an issue that you needed legal assistance beyond what's enumerated under what I would call the no charge or no additional charge benefits, then it'd be up to you at your discount, and you would get a discount off their hourly rate to hire them beyond that. So you having that plan would give access to Demi Parker for you and your family based on your personal legal needs if it's a personal legal plan.
Thank you.
All right, any other questions for this witness? All right, we'll move on to Kevin Almaroth.
Thank you, Mr. Chairman, Representative Smith and members of the committee. As Mr. Chairman just mentioned, my name is Kevin Almaroth. I'm the managing partner with the law firm of Deming, Parker, Hoffman, Campbell, and Daly here in Atlanta. We've been the Georgia provider firm for prepaid legal services for over 31 years. We'll celebrate our 32nd anniversary as the Georgia provider firm this summer. And on a yearly basis, we're now servicing 86,000 Georgians pursuant to the Legal Shield prepaid legal services plan. There was some discussion, and I appreciate Representative Evans bringing it up, about what really is the primary benefit of this possibly. And I've always looked at the primary benefit to the members we service as being access to counsel, and Mark talked about that as well. And so what that access to counsel affords those members who contact our office is basically an expanded scope consultation. So we're not acting in a representative capacity at that point. It is an expanded in scope consultation, and what it entitles the member to, first and foremost, is same-day consultation with an attorney. It also, when necessary, involves document reviews and us conducting research on that member's behalf. And then most importantly, if it's appropriate in our professional opinion, to write a letter or make a phone call to an opposing party in an effort to try to get the matter resolved, that's what we do. Beyond that, we may reach a fork in the road where we've provided those initial consultation benefits to a client, and the client wants counsel to stay involved in the matter, in which case they are then entitled to retain counsel at a discounted rate. So we're not paid anything until such time as we enter into a traditional attorney-client relationship that's governed by a retainer and their entitlement to retain counsel at a discounted rate. I will be happy to answer any questions anyone may have regarding how the service works. I do want to add, Representative Smith, the most distressing news to me about our shared undergraduate experience is that I attended my 30th reunion on the same year that you graduated. So it was a pleasure to know that you graduated from the Citadel as well. Thank you.
All right, thank you. Representative Wilson.
Mr. Almaroff, conceptually, I understand what we're talking about here, but I'm trying to visualize a real world example of what we're talking about here. Who are these 86,000 clients or Georgians? Are they small business owners? Are they all small business owners? I think, when we first started talking about this, I was thinking about, as a former teacher, you join the teacher union and there's lots of benefits that come with that membership. You get, access to insurance is one, access to legal counsel is another. Is that kind of what we're talking about? Who are the people we're serving? Who are they?
We're serving people to a great extent, just like you and I. So we have small business owners, we have retirees, we have employees who are part of employer groups, and the benefit is provided to them as an employee benefit. We have law officers. We represent a number of law officer groups throughout the state of Georgia. So basically, the membership base is a snapshot of our community at large. We do have a statewide practice, so we cover matters in all 159 counties in Georgia. But again, primarily what we're dealing with, and the way I always look at this is from the standpoint of access. Most folks don't know an attorney, they don't have access to counsel, they don't go to church with someone who is an attorney, they don't have a neighbor who's an attorney. And so this takes that part out of it, in that if they're in need of legal services for any matter, they contact our office. The other interesting thing to me is what the benefit that we provide these 86,000 members, and this is a membership base that is growing all the time, but the benefit that we provide to them is interesting to me. And I sum it up sometimes by saying, what we're doing and what the benefit we're affording these clients under their initial consultation benefit is forcing opposing parties in many cases to do the right thing. And but for our involvement on this member's behalf, they would not do it. By way of example, when we send letters to opposing parties or make phone calls trying to resolve matters, this is done at no out-of-pocket expense to the member. And last year, in 2021, we collected and recovered or saved clients under their initial consultation benefit $1.675 million. And that is money that they're not having to pay out. And in many cases, most folks don't have the financial means to do that. I've always said most folks, myself included, don't have a pot of money sitting at home marked unanticipated legal fees, and they can go and access those funds when they need to retain counsel. And so the real beauty, not only of access to counsel, but having that expanded scope consultation that affords them one bite at the apple. In other words, an opportunity to get somebody to try to help them right a wrong without them having to incur the additional expenses to try to make that happen. And in many cases, it may not be a sum of money that even justifies getting counsel involved. In other cases, it may well justify getting counsel involved and they don't have the financial means to do it. So there's a real benefit to those folks. But honestly, I think they're just like all of us.
Mr. Chairman, may I ask one more?
Yes.
Mr. Almaroff, is this a standalone service, or is this a service that's often packaged with other membership benefits, or is it both?
And Mark may be able to clarify a little more clearly. I would argue that it's probably both. We have an affiliation with Primerica, and it's often offered in conjunction, bundled with other benefits that folks may get, typically through an employer or in other packages. And Mark, is there anything you'd like to add to that?
And very good question. I would just say this, it's standalone from the sense that no one's required to have any other plans or benefits or anything else to have, to be able to have a legal plan. And so they may be offered in conjunction with other plans and other benefits, but it's not required. It's just really on the offering. So hopefully that helps. I'll say too, sir, I appreciate you bringing up educators. My undergraduate and I was a school teacher before I went to law school at night. So very much appreciate our teachers. And we have many teachers who are members and many school districts who we visit every year to provide the opportunity for them to get a plan. So thank you for bringing that up.
Mr. Representative Holcomb.
Thank you, Mr. Chairman. I'm not familiar with this, so I'm listening and trying to understand it too, but can you provide more clarity in terms of what exactly people get? I just did a quick scan of the website and it looks like they get some initial consultation, but then do they also get prescribed amounts of legal time per service? Like, for example, if I get a ticket or if I have something different, is that an additional fee or is that all included in the $29.95 per month? And if my math is correct, and it is, that's 2.5 million a month that's coming in the door on 86,000, which is not nothing. So I'm just wondering what those folks are getting for that.
I'd be happy to start on that, sir, and then if Kevin wants to interject anything. A basic legal family plan, right, would not only for you, sir, if you're married or have a domestic partner, children, stepchildren. I'm a blended family. We have 5 together. It would cover both my spouse and I and the children. It provides on the base what we call consultation benefit, consultation, document review, letter of call. It also provides basic estate planning benefits. You and your spouse, or if you have an adult child who's covered, could get their will, advance directive, and power of attorney done at no additional charge. If you want to do trust planning, you would get a 25% discount. It does provide for you, your spouse, and children, drivers, help on moving violations, mostly speeding, right, stop sign, failure to yield, those things. You would not pay an additional fee to have Kevin, his firm, help you. And traffic is a huge part of the benefit, as you can imagine. There are certain trial defense, pre-trial and trial hours that you would have under your plan if it was a covered matter as a defendant in a covered civil matter. There are some IRS hours and benefits available. And then there's what we call preferred member discount, or 25% discount off the hourly rate. I will say this too. We have an emergency access line that is, as you can imagine, in particular circumstance, is very important. And each provider, including Kevin's firm, has attorneys who are available 24/7, 365 days a year, if you have a legal emergency. And I've seen those type of matters, and it's been invaluable for those members. So that's also included in your plan for that monthly subscription fee. So all those people would be covered under that family plan. And the only thing that maybe for, say, an adult child, the trial defense benefits wouldn't apply to them. It would apply both to you and your spouse, but most everything else applies to everybody who's covered.
Mr. Almerath.
Yes, thank you. Yeah, I touched mostly on the expanded scope consultation, but Representative Holcomb, and I'll just dovetail on what Mr. Nelm said. It's pretty much the same thing, but this is a comprehensive benefits plan, and that's really the best way to look at it. We are resolving probably 80% of the request for service that we get under that initial consultation benefit. However, for those clients that are in need of further involvement of counsel, and it may be through the traffic benefit, which entitles them to representation in court on traffic-related matters with certain exceptions. It entitles them to representation in cases involving vehicular homicide. with certain exceptions as well. It also entitles them to representation if they are named as a defendant in a civil action that is not considered pre-existing in nature and for which they have what we would consider to be a valid legal defense. And as Mark indicated, they also have some IRS audit benefits. Beyond those benefits, they're entitled to retain counsel at a discounted rate. And so that's really how comprehensive the package is. Although most of those, 20% of the cases in our office are referred beyond that initial scope consultation.
Okay.
All right, let me add, would the, like in vehicular homicide, would the exception be a felony grade versus a misdemeanor?
That's correct. And the exception in vehicular homicide and traffic in general is typically if drugs or alcohol are involved, if there is a person's fleeing and eluding the police, driving without a valid license. But that's correct. The designation in Georgia, not every state does this, is between first and second degree.
All right, thank you. Chairman Administration.
Thank you. So this may be more appropriate for Mr. Nelms initially. So your business that you're talking about, you're doing business under the name Legal Shield, is that correct?
We're mostly known as Legal Shield. That's correct, sir. We're a DBA in Oklahoma, not in every state. Our parent, as far as for most subsidiaries, is Prepaid Legal Services Incorporated, an Oklahoma corporation. In Georgia, because it's a regulated state, we actually do business there under Prepaid Legal Access, Inc.
Okay, but it's not a law firm.
Oh, no, sir. No.
Okay. All right. And how many providers do you have in the state of Georgia?
When we say provider law firms, Demi Parker is the provider law firm, similar to Oklahoma, Riggs Avenue.
You have one provider law firm in the state of Georgia.
Yes, sir. But
All right,
then we have, I don't know the number offhand, Kevin may, but there's a significant number of referral attorneys outside of Demi Parker that also receive business from members from the law firm.
Okay. Deming Parker then refers cases out sometimes, is what you're saying.
Correct.
Okay. Is Deming Parker's firm referenced in the agreement with the person paying this monthly amount, or is it included in terms of service that you have with the people who are paying you the monthly amount?
Make sure I understand that, sir. Can you repeat that?
Yeah, sure.
Is Demi Parker?
If I'm paying you $29 a month, whatever it is Deming Parker's law firm referenced in the agreement that I have with your office, with your business?
Sure. Not Deming Parker specifically, but it does set out, of course, that all requests for services must be directed to the provider law firm in your state of residence. We rarely have turnover. We really do.
That wasn't my question. You answered my question before you talked about that.
Sure.
All right. You mentioned earlier that as part of this, I'll just call it, as part of paying approximately $29 a month, you receive a discount for some legal services, like 25% off for estate planning, I think you said. Is that correct?
Actually, basic estate planning, what I call a will, power of attorney, advance directive, that is no additional charge on your membership.
Okay, for the next year.
Actually, you can get an update once every membership year, no additional charge.
Right. You referenced just a moment ago that there was a type of legal service that folks who are paying this $29 a month would receive a discounted rate of.
Yeah, I was referring there, sir, to like living trust planning.
Okay, so for living trust planning, are you receiving the what is the how is the firm being compensated for the discounted rate that you are promising to these people paying $29 per month?
Sure. That's, as Kevin was referring to earlier, an agreement between the member and the firm.
Okay, so so your business is not having to pay any amount for a promised discount rate. It's just an agreement that Deming Parker would have with the ultimate client that there would be a reduced cost for that service.
Exactly. Yes, sir.
Isn't it true that the benefit of that reduced cost to the consumer is interpreted as coming because they are paying a monthly rate?
Interpreted.
Doesn't a customer believe that they're paying the $29 per month so they can get the discounted rate for that service later?
Well, as Kevin mentioned, sir, vast majority of the benefits that members receive every month and utilizing the services are done under the benefits where there is no 25% discount needed. So they're not, I would argue, I guess your
Deliberately
question.
trying to not answer my question. So I have
No,
no
I'm
further.
sorry.
Thank
No,
you.
I'm sorry, sir. As far as the discounted rate, I just want to make sure I'm clear on the question. It's like, again, if I have any other kind of plan, there's certain benefits under the plan, depending on what my needs are.
Mr. Chairman, it's clear I have some concerns. I chair the committee that oversees this subcommittee, and I'm happy to make a motion to table if that's necessary, so that we can give the folks who are supporting this legislation time to make sure that the committee members have all the information that we need, so that we can make the appropriate determination on the legislation. But I certainly don't want to cut off questions if anybody else has them.
All right, thank you. Any other questions? Tyler Paul.
Mr. Chairman, I'll second the chairman's motion.
All right. All right, I have a motion to table and a second. Everybody agree? Any opposed? All right, it's tabled. All right, thank you. And thank you, gentlemen. We appreciate it.
Thank you.
Thank you very much.